Music from the graveyard of long forgotten days, when deceit was the exception and corruption not the rule. Before this broken vessel had become a...
This is Laura Harmon.
Hey Laura, how you doing? This is Brian Green.
Hi, how are you?
Hey, pretty good, pretty good.
Good. I'm just pulling out the files. Give me 1 second.
Sure.
I don't know where it is. Okie dokie. Well, I can't seem to track it down. So anyways, did you get my message from last week?
I did, but I had erased it, so I totally I lost your number. So we had a family emergency this last week, and my health hasn't been all that great. So I apologize on taking so long to get back to you.
Oh, no worries at all. I just wanted to make sure it got to you. I'm sorry to hear about that.
It's a whole bunch of stuff at once. So, but I appreciate that. Thank you.
Yeah, I'm sorry. So your message said, well, how about this? Tell me what you'd pretty much like to focus on.
Okay. When we were in court, I had made a challenge to jurisdiction, and the judge had said that I needed to ask the questions of the prosecutor, I guess. So I'd like to continue that the questions on jurisdiction.
Sure. So I think, and I wasn't there, this is just my understanding from the notes and such, is that she asked you to file something in writing. Do you remember that at all?
Oh, certainly.
Okay. So I think that would probably be step number one, would be getting something in writing.
Well, I've already got that, but to proceed, actually, that requires jurisdiction, and the problem I see here is that there's no corpus delecti, and there doesn't appear to be an injured party. Is there any allegations of injury or any true adversary an adversary in this case?
So I guess I'm kind of confused. So are you talking about the merits of your jurisdiction issue, or are you talking about a separate issue of corpus delecti?
Well, to have jurisdiction, there has to be a body of there has to be a body. There has to be a case. There has to be corpus delecti.
Right.
So I don't see any of that. I got some papers from your office, but I didn't see anything in there that alleged any injury or.
Did you get discovery in the mail?
Yes, but I hadn't put in my request for it. I still need to put in a request because I also need a Brady list.
There is no Brady list on this case.
Okay, because it
was just those two officers involved, and neither of them are on such a list.
Okay.
But you did receive the discovery. That's good. And you don't need to put in a request for it because you're appearing on representing yourself. So
right.
That's basically what that was.
But in there, I didn't see any evidence of any injury or basically any real crime. So I'm just kind of curious. I mean, I saw a lot of statements in there, but none of them, no evidence that I had committed any injury or caused anyone a loss.
Mm-hmm. Yeah, it would just be based off of the charges at arraignment. And you got a copy of that at arraignment too, right? The probable cause statement and the information?
Well, you see, that's just the whole thing. I when I asked about jurisdiction, that's, isn't that supposed to be... Weren't you supposed to answer the questions about jurisdiction because that was never established?
Sure. So essentially, if you have a challenge to jurisdiction, and it sounds like that's what you want to bring forward at this time, and you have some paperwork, go ahead and file it with the court and serve a copy on my office or send a copy to my office, and we can address it at the next hearing.
I have one more question for you. Oh yes. Now, if I send it, does it have to be postmarked by the end of this week, or does it have to actually arrive in your office by the end of this week?
Oh, that's a good question. I'm pretty sure it's by the time you send it. It's called the mailbox rule, and honestly, I'd be flexible as long as it's before that next motion date we have, which is escaping me right now. Do you remember when that motion date was set by the court?
I don't. But you're saying that there is no injured party. Is that correct?
I guess I'm confused by the question. You have been charged with obstruction.
Well, for the Constitution and laws to apply to me, there has to be an injured party. Mm-hmm. So I'm wondering, who is the injured party? That's what I'm asking. To have jurisdiction, there has to be an injured party.
Well, it would be the law enforcement officer of the obstruction.
So the law enforcement officer is the injured party. He's claiming injury.
Well, it's less that he's claiming injury and more that the state of Washington filed charges.
So the state of Washington is claiming injury?
Not injury to himself. So
I don't understand. There has to be injury.
As a prosecutor, I represent the state. And I understand that you're kind of asking to what the injury is, and all I can really...
Well, the injury is what gives jurisdiction. So I'm asking about jurisdiction. This is still a question from when we were at the hearing the other day. Was never answered, and it still it hasn't been answered. I'm curious. I need it to be answered so that we can either move forward or have it dismissed.
Right, and that's what we'll address at that hearing. And what would just be best from I think my perspective, so I can properly answer your question, is if I can have what you have in writing, so I make sure I understand all the parameters of your argument and I can respond accordingly.
Okay, but you're saying that the state of Washington is the injured party.
I'm saying that I represent the state of Washington and that you're being charged with obstruction of a law enforcement officer. I don't know how else to answer it, if that makes sense. Because frankly, it would be nice to see what you have so I can fully understand what we're talking about. And I understand that's kind of a vague answer, but I guess I need more information at this point.
Okay. Well, I'll send that out to you, and then perhaps we can talk after that. Would that be okay, Laura?
Yeah. And I'm sorry. I'm going to pull up this date just because it's bothering me that I don't remember it. There we go. Okay, so this got set for a motion date on February 13th.
I believe that is correct.
Okay, and that you were to file something in writing by a week from Thursday, the 29th.
Okay. Oh, I thought it was the 23rd.
So. Oh, no, my notes at least say the 29th, which would make sense because that would be a full almost 2 weeks before the hearing.
Oh, outstanding. I'm already finished with that then. Okay.
Oh, good. So then, yeah, that's done.
Okay.
And then the readiness would be on the 18th of February and jury trial 23rd.
Okay. Well, it's as long as jurisdiction's answered, I guess, properly.
Right.
Okay.
Yeah,
well,
we would still need to address that. You're right.
Yes. Thank you very much. I really appreciate your time, Laura, and I'll be talking to you soon.
Yeah, of course. And I want to make sure. I think previously in your message you had said that you had some concerns about being able to represent yourself and file this. Do you have any of those concerns at this point? Oh, no.
It was I was just concerned about where and how I should file if there wasn't a proper jurisdiction or court identified.
Oh, I see what you're saying. Yeah, you can just send them to the court, to the Pierce County District Court, and then we'll address it at that hearing and proceed accordingly based on whatever the ruling is.
Thank you, Laura.
Yeah, and feel free to give me a call if you have any other questions. I know you said you erased the voice message. Would you like my direct line?
Yes, I would, actually.
Okay, so it's 253.
Okay.
798.
Okay.
6734.
6734. All right, once again, thank you again.
Yes, of course. Thank you for the call. Have a good rest of your day.
You too, Laura. Bye-bye.